So we have some important news in the current efforts to remove suppressors and short-barreled rifles from the NFA nationwide. 15 states just joined in support of ending all of the remaining NFA restrictions, and now this case is moving forward to remove those immediately. Now, before we jump into this video, I want to ask you guys for a favor. If you support this type of 2A content, please consider subscribing to the channel. That, of course, helps the channel to grow. Also, just double check to make sure YouTube is not unsubscribed to you because they love to do that. Also, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to protecting yourself after a self-defense incident, AOR, in my opinion, is in a league of their own. They have an actual law firm that backs them, the Attorneys for Freedom, so they can help you in self-defense situations that other companies may not. And right now, they've expanded a lot of their benefits, and if you sign up this year, you can lock in your price for the future. So I highly recommend that you sign up this year, and you can do that using my links down below in the details section, also in the pinned comment. And if you use my code ARMEDSCHOLAR, you can get $50 off of your individual sign-up plan or $25 off of a family plan. So as I mentioned in the intro, in this video, we need to talk about what is currently happening right now in response to the One Big Beautiful bill, the reduction of the NFA tax from the $200 tax to $0, which was passed in the Big Beautiful bill. Now, if you've been following the channel, you know that HR 1 passed, was signed into law, and takes effect, I believe, at the beginning of next year. And that was only a reduction of the NFA tax. Under the new law, the NFA tax has been reduced from $200 to $0. And also, unfortunately, rhinos in Congress were unwilling to press this issue to get the full version of the Short Act and the Hearing Protection Act that we wanted, which would remove all of the NFA restrictions on those items. They were also unwilling to remove the Senate parliamentarian who was responsible for striking out the full language of the bill that we wanted. And also what we've seen in response to this is a ploy by some Democrats like Senator Chris Murphy, who have now, in response to this $0 tax change, tried to introduce proposed amendments to some spending bills, which would actually increase the NFA tax all the way to $4,709 per stamp. So the Democrats have taken action in response to the NFA tax changes, but now multiple 2A organizations have launched challenges to remove the remaining restrictions on suppressors and SBRs. We've seen lawsuits filed by organizations like GOA, FRAC, Silencer Shop, Palmetto State Armory, Silencer Co., and others who have filed lawsuits against the ATF. And now also we have seen in this same lawsuit, 15 states have joined as plaintiffs in support of this challenge. Now, if you're interested, those states include Texas, Alaska, Georgia, Idaho, Indiana, Kansas, Louisiana, Montana, North Dakota, Oklahoma, South Carolina, South Dakota, Utah, West Virginia, and Wyoming. And now this coalition of 2A organizations and states are moving to end this lawsuit and essentially end those remaining NFA restrictions right here and now. The plaintiffs just filed their motion for summary judgment in this case to strike down the remaining NFA restrictions immediately on SBRs, suppressors, SBSs, and AOWs, which are no longer taxed. Now, in this lawsuit filed by these plaintiffs like Silencer Shop and others, they argue that since there is no longer a tax on these items like suppressors, SBRs, SBSs, and AOWs, there's no longer a valid constitutional basis to further regulate and restrict these items under the NFA. In summary, what GOA and these other plaintiffs asked for in this challenge is for the court to declare that the NFA's registration and transfer requirements no longer have a valid constitutional basis, and therefore it should be enjoined. So that is what the new lawsuit aims to do in response to the NFA tax changes that just passed in the Big Beautiful bill. And now the plaintiffs filed their motion for summary judgment to end the case sooner rather than later. Now what this means is essentially both sides here, so both the plaintiffs and the Trump DOJ through the DOJ, are seeking to end this dispute as soon as possible without going to a full trial. The plaintiffs, in their recent motion for summary judgment that they just filed, they argue that applying the NFA to the now untaxed firearms is flatly unconstitutional. The reason is simple. Congress cannot use its taxing power to sustain a statute that does not collect a tax. Thus, the NFA is unconstitutional as applied to the firearms it does not tax. And under binding Supreme Court precedent, the NFA is only a taxing measure, and courts may not ascribe to Congress an attempt to exercise another power to sustain the NFA. That ends this case, they state. The government nevertheless may attempt to defend its measure under the Commerce Clause and the Necessary and Proper Clause. As already explained, they state that is a non-starter. But even if the court were to reach that question, the NFA cannot be sustained under the Commerce Clause as applied to the purely intrastate possession, transfer, and making of these NFA firearms. So the plaintiffs argued there is no longer any constitutional authority for Congress to regulate these now untaxed items. So now that SBR, suppressors, AOWs, SBSs will no longer be taxed, they argue that there is no constitutional authority to regulate these items. The taxing power does not work because there is no longer a tax on these items, and the Commerce Clause in this context should not apply to purely intrastate possession of these items like suppressors and SBR. So if these items are purely possessed within a state, they don't go, interstate, they don't travel across borders or anything like that. If these are purely only a possession restriction on these items within a state, well, then the Commerce Clause also does not apply. They then move on to the Second Amendment arguments against the remaining NFA restrictions. They argue that the challenge provisions not only exceed Congress's enumerated powers, they also infringe Americans' enumerated rights. The Second Amendment protects the right of the people to keep and bear arms. The firearms at issue here are undeniably arms under the text and plain meaning of the Second Amendment. Under New York State Rifle and Pistol Association versus Bruin, that means that the NFA's regulations are presumptively unconstitutional, and the government bears the burden of proving the constitutionality of its actions. So what this means for this lawsuit in relation to the now $0 tax items and the attempts to remove all the other NFA restrictions on those items, essentially moving forward, now both sides are filing to end this case on summary judgment motions. The plaintiffs believe that the NFA's remaining restrictions by default should now essentially go away because the remaining SBR and silencer restrictions are dependent on the NFA being a tax. They also argue that it cannot be sustained here under the Second Amendment because this is a two-way violation, and the government cannot show a history and tradition of categorically restricting the mere possession of certain items, like these items here, SBR, suppressors, and other items. So there are a lot of moving parts right now in this NFA battle. Lawsuits have been launched now as a result of the $0 tax change. And also there were prior lawsuits that made their way all the way to the Supreme Court, and they're currently still pending in front of the Supreme Court. And the Supreme Court has asked for responses from the federal government in those cases. It's going to be interesting to see how the Trump administration now responds to the motion for summary judgment, and what do they say in their own motion for summary judgment? What are the arguments that they're going to present for why the NFA still operates as a constitutional law, and why they can still put in place a registration and transfer restrictions on these items, even though they are now untaxed, even though now they have a $0 tax because of the One Big Beautiful Bill. So again, it's going to be interesting to see how these cases move forward. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, ARMEDSCHOLAR.com. Over there, we have a lot for you guys. But again, one of the best ways and the free way to support the channel is to simply subscribe to the channel and share these videos. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.